The Supreme Court has rejected a restrictive New York state law that limited who can carry a concealed weapon. The 6-3 decision ruled the law violated the Constitution. President Biden responded to the ruling, saying the need to curb violence still needs to be done on the state level and through Congress. New York City Mayor Eric Adams is reacting to the ruling.
It's clearly reached a point where we won't have any sleep. This decision is so impactful. When I spoke with my chief counsel, based on his preliminary analysis, I said, give it to me on a scale of 1 to 10. It's very close to a 10 of a major concern that we have. While we're still analyzing the decision, we can say with certainty, this decision has made every single one of us less safe from gun violence. The decision ignores the shocking crisis of gun violence every day.
Let's bring in Melissa Quinn and Robert Spitzer for more on this now. Melissa is a CBS News political reporter.
And Robert Spitzer is a distinguished service professor at the State University of New York, Cortland. He is also the author of 6 books on gun policy and has studied and written about historical gun laws extensively. Welcome. It's good to have you both. Professor, let me start with you. As someone who studied the history of gun laws here in the U.S., what's your reaction to today's Supreme Court decision?
Well, my reaction specifically regarding gun law history is that the majority opinion in the Bruen case bent over backwards to distort, disfigure, and misunderstand the history of gun laws in America, in particular gun carry laws. If you look at the history of gun carry laws in America, we have had them for hundreds of years. If you go from the 1600s to the start of the 20th century, 47 states out of 50 had laws restricting or barring concealed gun carry, and some states had laws barring open carry. Now, the idea that these old laws did not include a permitting system jumps over the fact that you simply couldn't carry guns in many states and that they were subject to various restrictions. They simply didn't institute a system of permitting. So in that sense, there was no precedent. But if you look at the arc of the laws, restrictions on civilian gun carrying were the norm, were the default in America for hundreds of years until the last few decades.
It's fascinating to hear that history there, Professor. Melissa, I'm going to turn to you now. If you could break this down for us, how significant is the Supreme Court's ruling today? What does it really address? Is it narrow? Is it broad? Tell us how much will change as the result of this ruling.
Well, the decision certainly is an expansion of gun rights, and the most significant that we've seen from the Supreme Court since its 2008 decision in Heller and then the follow-on case in 2010. You know, both the majority and also a concurring opinion from Justice Kavanaugh that was joined by Chief Justice John Roberts did note that the opinion leaves untouched concealed carry laws in 43 states, these shall issue jurisdictions where residents who do want to carry a concealed handgun outside the home do have to get a license if they meet a basic set of requirements. And what Justice Kavanaugh said in his concurrence was that this ruling really only affects not only, of course, the gun law in New York, but in 5 other states, Maryland, Massachusetts, California, for example, where they had similar licensing regimes on the books and gave broad discretion to government authorities as to whether to approve or deny these concealed carry permits if they decide that the person does or does not have a special need for self-defense.
So you just broke down there how the Supreme Court kind of arrived at this decision. Melissa, do we have a sense of sort of the implications here moving forward? You touched on it a moment ago.
Well, you heard from Mayor Adams and also New York's governor put out a statement, both saying that they intended to continue not only their review of the Supreme Court's decision, but also their laws to see if there are additional steps that they can take to tighten their gun laws. And I expect to see, I believe New York's governor alluded to this, second looks at these laws that place restrictions on where you can carry a concealed handgun, these sensitive places. That was also an issue in particular that was raised during oral arguments by Justice Amy Coney Barrett and the Chief Justice. So I would look to these sensitive places as to whether there are steps state and local lawmakers can take to impose those sorts of rules.
So, Professor Spitzer, to follow up on Melissa's point there, now that legislators, especially from states like New York that do have some of the nation's strictest gun laws, now that they're probably going to start looking locally, how broad can that be? Could, for instance, New York State legislature pass a law that says no one in New York City can carry a concealed weapon unless they have a specific reason to? So in other words, just making it about urban areas, or would that be considered too broad in light of this new ruling?
Well, the court majority was pretty skeptical of that sort of distinction because to them that represented a deprivation of rights to people living in a large city like New York. And lawmakers in New York and the other states that had similar, more discretionary permit laws will obviously be looking to sculpt new laws that conform to the standards set out by the Supreme Court. And indeed, there are the number of that's cited in the decision of 43 states with permitting isn't quite right. As of right now, 18 states have what's called a shall issue permitting system, meaning, and the court said expressly, permitting by states for pistols, for handguns is fine as long as it is the shall issue standard, meaning that as long as you're not a convicted felon, as long as you're not a judgmentally incompetent or discharged dishonorably from the military and a couple of other things, and you fill out the paperwork properly, you'll get your permit, and that's it. Now, 25 other states had a permitting system with one exception, but they have eliminated permitting entirely. So today, only 18 states have permitting, but the court said, yes, states can have permitting, they just can't have a permit system that was as strict as that in the New York State law.
Well, as we said, a significant decision today by the Supreme Court, even as the U.S. Congress continues to debate the crafting of gun control legislation. Melissa Quinn, Professor Robert Spitzer, thank you both very much.